Good afternoon. This is Ron Mickens. Fraud upon the court. The truth is in the details. One lie can only lead to another lie. The only thing that you can get from a lie is another lie. Oh, we know Mr. Jerry Hill, the state attorney, by now. He conducted this cover-up, this conspiracy to deprive Ron and Gloria Mickens of all of our constitutional and civil rights. And he did this to destroy us, to release and extricate the wrongdoers. Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, Harman-Highsmith, and the Damron from liability and responsibilities for their torts and their crimes, even after they had confessed. They had made confessions in their depositions, in their affidavits, even in Jerry Hill's so-called investigative report. Judge Strickland even examined Mrs. Canady himself, and she confessed, but he refused to prosecute her. He refused to do his job. Jerry Hill, instead, he conspired with Stewart Title Guaranty Company's lawyers, with all of their attorneys, to obstruct justice, to obstruct a criminal investigation by FDLE, the sheriff, FBI, and other law enforcement agencies. He filed his frivolous complaint to maliciously prosecute us, to maliciously misuse and abuse the legal process, to maliciously fabricate fraudulent misrepresentation, void orders, void judgments, to destroy us, to deprive us of all our constitutional and civil rights. Judge Strickland, he arbitrarily, capriciously going to replace his final judgment on our counterclaim with his own personal, unique, biased judgment. Okay? I don't have to say no more than that. That is not right. You don't go to court and prevail on the merits of your claims, and then the judge is going to turn around and substitute it with his own personal, detrimental remedy / judgment. That is not fundamental fairness. The Second District Court of Appeal had to reverse Judge Strickland's fraudulent judgment remedy because the relief that he provided was unsupported by the pleading, it was unsupported by the evidence, and objected by both parties. We, Ron and Gloria Mickens, was entitled to a judgment based upon Judge Strickland's determination that the quitclaim deed was void and on our fraud claim and cause of action. The Second District Court of Appeal used the term, if you again base your judgment on the determination that the deed is void, then Chase or its successors is an indispensable party to this action. This was coded language for Judge Strickland to disqualify himself. In other words, the Second District Court of Appeal permitted Judge Strickland to recuse himself or disqualify himself, to allow Judge Moore to fraudulently replace him. Okay? Judge Moore came in and she's going to produce and fraudulently impose this fraudulent misrepresentation of fraudulent judgment of rescission. And this fraudulent misrepresentation that she imposed was that Ron and Gloria Mickens essentially desired and sought rescission. Oh, this was the lie of the century. Because it's the lie of the century, because we have no right. It was over for us then. If somebody said that you essentially desired and sought, this is what you desired, this was her arbitrarily, capriciously, maliciously, outrageously, shockingly depriving us of everything, every right we thought we might even have. we were reduced to the status lower than a slave, lower than a 3/5 human being. Okay, not even legal rights. Please more talking about constitutional and civil rights. So this is why, from this point on, they could fraudulently create and do anything that they chose to. And they're doing this too to retaliate against Ron and Gloria because we rejected and objected to Judge Strickland's judgment on personal judgment that was outside the law. Now, what I'm going to prove to you, beyond any reasonable doubt, clear and convincing evidence, that Judge Moore order judgment of rescission is void. It is of no legal effect. It is of no legal force or effect. Both parties, we corroborated and we agreed that Judge Moore lacked jurisdiction. Nobody invoked her subject matter jurisdiction for rescission. Rescission was unavailable. Ron and Gloria Mickens had a breach of construction contract claim and cause of action. That's a remedy in law. When you have a remedy in law for breach of construction contract, rescission is unavailable. It don't even exist. Judge Moore rescission judgment was unnoticed. It was undesired. It was unsought. It was unplayed. It was unalleged. It was unheard. It was unsolicited. It was unlitigated, unadjudicated. It was unnecessary. It was inappropriate. It was improper. It was objected to by what? Both parties. A total denial of due process. Now, I could never tell you how evil this trick is when Judge Moore fraudulently misrepresented that we essentially desired and sought rescission. Both parties corroborated and agreed that this was factually and legally incorrect for a number of reasons. It was unsolicited. We were both denied due process. It was unavailable. Okay? This was just arbitrary, capricious, to deprive us of everything, all of our Constitution and civil rights. This was the goal that Jerry Hill set when he and Stewart Title Guaranty Company conspired to file that frivolous complaint. So Judge Moore did the so-called impossible. The Second District Court of Appeal could not do it. They couldn't reverse the trial judge, but Judge Moore going to criminally use rescission to replace, to supplant, reverse, overturn, abort, abandon, annul, ignore, obsolete, void, circumvent, avert, dismiss, vacate, set aside, omit Judge Strickland's adjudicated findings on our fraud, cancellation of deed, qualified ejectment, and breach of construction contract claim and causes of action. Ladies and gentlemen, you can't overturn the trial judge. This is fraud. Judge Strickland's findings is protected by res judicata and collateral estoppel. They are binding as a matter of law. So you got to understand that Judge Moore rescission judgment is totally fraudulent, void, and is of no legal force or effect. Judge Moore imposed rescission to obstruct us from joining 22 additional claims and joining the necessary and indispensable parties: Stewart Title Guaranty Company, Stewart Title of Polk, Canady, Rewis, Harman-Highsmith, and the Damron. They all were co-conspirators when it came to the validity and the invalidity of the quitclaim deed. They all co-conspired and made the fraudulent quitclaim deed. In other words, this was a trick for us to give up 27 claims in lieu of one claim, or in exchange for one claim, where she's gonna order us to pay a nominal party, a party who don't even have a real interest. This was a non sequitur. This is a professional liar. Okay, a non sequitur is an inference or conclusion that does not what? It does not follow. It does not establish. It does not follow the established premise or evidence. It does not follow. It does not come after in time when an action or decree is non-sequitur. It is unrelated to the preceding event. A non-sequitur is something that has no logical or temporal purpose for its place in the progression of events. In other words, rescission of the construction contract do not follow rescission or cancellation of the deed. What followed was we adding the indispensable and necessary body and our additional 27 claims. That is what followed. And then Judge Strickland enforcing his final judgment. But you got the Second District Court of Appeal has really authorized Judge Strickland to disqualify himself and to allow Judge Moore to replace him and impose this fraudulent misrepresentation that we essentially desire and sought rescission to deprive us of all of our constitutional and civil rights. Okay? That was their goal, to deprive us of all of our constitutional and civil rights. Now, stay with me on this. I had to keep a low profile for several years because my family, my friends, my associates was 100% convinced that I was going to be murdered because they had been caught in this matrix of lies, that they had been caught depriving me of all of my constitutional rights, caught committing fraud upon the court for the blood money. Ladies and gentlemen, it's clear. They did it from day one. They planned it from day one. So they had to set me up and my wife to be murdered with fraudulent misrepresentations, with fraudulent orders, and fraudulent judges. Now, stay with me because you got to understand, Ron and Gloria Mickens didn't do anything to anybody. We did not infringe on anybody's rights or property. Okay? They stigmatized us, called us lawless, even started equating me with Columbine High School in Conyers, Georgia's murderers, set me up to be killed. They had already false arrested me and imprisoned me for just telling the truth, based on the facts, based on undisputable facts and evidence. Jerry Hill, the opposing attorney, and the judge showed that they didn't get absolutely nothing about us, our constitutional rights, or anything else. Okay? What you got to do, you got to help me hold these people accountable because it is time for a change. Power is in the people. People with knowledge is power. You got to hang in there with me because I'm going to break it down to you. Everything that they produced was fraud, and it came from Judge Moore, fraudulent misrepresentation that we essentially desire and sought rescission. Okay? The Supreme Court precedent law 100% proves that Judge Moore's order is void. I can share with you some of these quotes. A void judgment is not entitled to the respect accorded to a valid adjudication, but may be entirely disregarded or declared inoperative by any tribunal in which effect is sought to be given to it. It is attended by none of the consequences of a valid adjudication. It has no legal or binding force or efficacy for any purpose at any place. It is not entitled to enforcement. All proceedings are founded on the void judgment or themselves regarded as invalid. It is a fundamental doctrine of law that a party to be affected by a personal judgment must have his day in court and an opportunity to be heard. Every person is entitled to an opportunity to be heard in a court of law upon every question involving his rights or interests before he is affected by any judicial decision on the question. If a court grants relief, which under the circumstances it hasn't any authority to grant, its judgment is to that extent void. An illegal order is forever void. The Supreme Court law just goes on and on. A void judgment does not create any binding obligation. An order that exceeds the jurisdiction of the court is void. Judge Moore order violated all of these fundamental due process rights. It was what? Arbitrary. It was capricious. It was malicious. It was outrageous. It was lawless. Okay? She controlled everything when she told that lie that we essentially desire rescission. That's something that Judge Strickland couldn't do. But once she added that fraudulent misrepresentation that we desired, that took our life, liberty, and property away, all of our constitutional and civil rights, liberal rights, and all other rights. Hey, that's it for the day. Okay? In the words of Ida B. Wells, the way you right wrongs is to shine the light of truth upon them. Hey, I'll talk to you down the road.